Thank you, my lady, my lords. I appear with Mr. Stratton, the appellant. My learned friend, Mr. Standish, appears with Mr. Belshaw for the first respondent, and my learned friend, Mr. James, appears for the second respondent. With the court's permission, Mr. James and I propose to sit in the front row.
Of course.
There are a few points of housekeeping before I start.
I'm aware of that. Can I first of all say on behalf of all of us, we are conscious that this appeal has been expedited, and we are very conscious of the efforts all have made to ensure that the court has all relevant documentation and the personal movements of counsel have not gone unnoticed by the court as well. So we are very grateful to everyone for the very considerable efforts they have made to ensure that we can have an effective hearing today. Thank you.
Thank you very much, my lady, and I'm sure I speak on behalf of everyone here that we are all very grateful to the court for expediting this matter so quickly and hearing us today in the middle of August.
Well, we're here. Just one other thing. I have been informed that although this is being live streamed, in fact, everyone is in court in person. Is that correct?
As far as I'm aware, that's correct.
Well, for the avoidance of any doubt, if anyone is attending remotely, can I just make this observation, that there can be no recording of this, there can be no photographs, because anything along those lines would be treated as contempt of court.
Thank you very much, my lady. I think it's important to point out that the transcribers are working remotely and are taking a transcript remotely, which I understand.
I signed it off yesterday, so it is appropriate.
So that's permitted.
Yes.
The next point of housekeeping is, obviously, in relation to the transcribers, I will try and keep an eye on the clock to allow them the usual breaks for in the middle of their transcription to allow them to get through the day. Is that acceptable?
Of course it is. The other point is this. Have you spoken amongst yourselves on timings, how you're carving it up?
We haven't. I think we were rather assuming that having effectively had this argument in front of the judge, we were likely to follow similar timings. And my guess was that my learned friend would be on his feet until sometime shortly before lunch, that I would then be on my feet, and that he would then reply, and that we would aim to take roughly equal time. I'm confident that if we do that, we'll be able to finish within the day, my lady.
Good, thank you very much. And just again, on just to identify one point, the third respondent has played no part in these proceedings. And I can tell you that my clerk, who has been in touch with the parties to ensure we have all relevant details for the sending out ultimately of the judgments, has had no response whatsoever from the third respondent or any who may have been acting on his behalf.
Yes, I understand, my lady. The third respondent obviously has difficulties in being subject to sanctions.
Yes, indeed.
The next point is in relation to our fourth ground of appeal, which relates to the costs.
Yes.
We have received this morning from the court the transcript of the hearing and the judge's ruling. The relevant passage is very short. I would think that we may be able to deal with that today as a result, with the court's permission.
I think you may be optimistic on that. I think we're going to have to see how we go.
I understand, my lady. We will see how we go then, and we can deal with what happens as seeing where we end up. The next point of housekeeping is that we received an email, I think, from your ladyship about references in the book relating to the law of compelled evidence by Mrs. Justice Cockerell. Both the first respondent and the appellants have written to the court this morning with passages from the book that they think may be relevant. There are two different chapters that have been sent, one chapter 4 by them and chapter 5 by us. Have they been received?
Thank you very much.
I've had chapter 4, not chapter 5.
It came in later.
Oh, right, I haven't got that with me. If you have a copy of chapter 5, that would be helpful.
I have many copies. Do you want to have them read? Sure.
Very much.
And that relates to my final point of housekeeping, which is relating to the authorities bundles. We received the information that the court was not going to take the new bundles and that we were to hand up the additional authorities. We have the additional authorities in a supplemental bundle. I think that's probably the easiest way to do it, is to hand them all up in that form.
Yep.
Next.
It wasn't that we didn't appreciate. It was quite simply, I saw the email shortly after midday yesterday, and I knew the work I'd done on the authorities bundle. I was aware of the work my colleagues had done on it, and therefore it was just one of those occasions where, notwithstanding the best efforts of all, it wasn't going to produce the solution.
I completely understand. I was in the same position, but I had the benefit of Mr. Stratton putting the two bundles together to make one.
I think you should be relieved of the box.
Oh.
That's very kind of you.
Thank you very much indeed.
Thank you.
Right. And you wanted to hand in what would be tab 9 of the core bundle, didn't you? Look, don't worry, it can come through in time.
All right. Thank you very much, my lady. For the time being, then, we have 3 grounds of appeal. First is that there is no jurisdiction to permit service out of a non-party disclosure application on a witness outside the jurisdiction. And there are 2 limbs to that. First is a matter of construction of Section 34 of the Senior Courts Act, and the second is the construction of Gateway 20. The second ground of appeal relates to the proper basis of the exercise of discretion, if there is such jurisdiction. And we say that even if there were jurisdiction to allow service out, the discretion should be exercised against permitting service out, in all but the most exceptional circumstances, perhaps, to avoid trespassing on the carefully negotiated Hague Convention and the long-standing practice of states under the letters rogatory process. And the third ground of appeal, which is rather separate, relates to the proper basis for allowing alternative service where the Hague Service Convention is engaged. Turning to the first ground of appeal, it's common ground that an applicant seeking the court's permission to serve an application notice out of the jurisdiction must show 3 things. First, that the application is a claim falling within one of the jurisdictional gateways. Secondly, that there is a serious issue to be tried. And thirdly, that in all the circumstances, England is clearly or distinctly the appropriate forum, and that the court ought to exercise its discretion to permit service out. The only gateway upon which Mr. Gorbachev relies is Gateway 20. We don't need to turn it up, but it's at page 410 of the White Book. It provides that the claimant may serve a claim form out of the jurisdiction with the permission of the court, where a claim is made under an enactment which allows proceedings to be brought, and those proceedings are not covered by any of the other grounds referred to in this paragraph. So the critical points there are that whether it's a claim, whether it's a claim under an enactment, whether the enactment allows proceedings to be brought, and it's common ground that that means the enactment allows proceedings to be brought against persons outside England and Wales. And the critical subpart of that is whether or not a Section 34 application allows proceedings to be brought, or whether it's only concerned with the power of the court to make an order within existing proceedings. The first reason we say why there is no jurisdiction is as a matter of construction of Section 34 of the Senior Courts Act. The important question is the territorial application of that provision. As the Court of Appeal said in the case of Erexum Trading Limited and Mahavir Port and Terminal Private Limited, 2018, EWCA Civ 1660, this is a question of construction of the particular legislation. Now, I think it's common ground that there is nothing in the express wording of Section 34, or for that matter, Rule 31.17 of the Civil Procedure Rules, which provides that such an order may be made against a person who is not within England and Wales. So Mr. Gorbachev says that it is implicit in Section 34 that it has extraterritorial scope. And we say it's not, and we say there are 5 reasons of principle that go to the construction of that section, which explain why that section does not have application outside England and Wales. First reason is that it is an important principle of statutory construction that unless the contrary intention appears, an enactment applies to persons within the territory to which it extends, but not to other persons. And that is commonly referred to as the presumption against extraterritoriality. The second reason is that an order that a party give disclosure to a sister court in its process is a sovereign act. And by making such an order against a person in a foreign state, the court may be taken to be encroaching on the sovereignty of that state. This is a powerful reason why it is unlikely that Parliament would have intended Section 34 to have extraterritorial application, and an important factor in the construction of that section. The third reason, which is closely connected to the second, is that it would be contrary to principles of comity between states to make an order for disclosure against a foreign non-party in circumstances in which the English court would itself refuse to give effect to such an order or request from a foreign court. An English court will refuse a letter of request made by reference to broad categories of documents or a broad relevance standard. Any request must be made by reference to specific documents. As a matter of principle, therefore, it has been held that the English court will not make a request of a foreign court in wider terms. This, again, is a powerful factor in construing Section 34. We submit that it would be quite surprising if Parliament had intended the court to achieve such a result, and Parliament had intended the court to achieve such a result, which would bypass the foreign court altogether and allow the court to make broad disclosure orders against parties within foreign states.
Isn't the question there not so much to do with whether the English court would accept or refuse to make an order on an incoming request, but rather what would be the attitude of the English jurisdiction if a foreign court were to start making orders against people here which did not require the involvement of the English court, because the point about Section 34 is that you don't have to go to the court in Cyprus or wherever. It's simply an order which the English court makes for itself.
My Lord, I think that there are two parts to my reply to that question. The first is that I think that the logic that the English court will not make a letter of request that it wouldn't itself honour is relevant by analogy to the construction of Section 34, even though it's not concerned with precisely the same question. There is, though, a related point, which is that the English court and the English jurisdiction has been critical of attempts of foreign courts, particularly the courts of the United States, to order English companies to give disclosure in aid of proceedings in the United States. That's a point made by Mr. Justice Hoffman, as he then was, in the McKinnon case, which we can look at in due course. And that relates to the point your Lordship is making about an order for disclosure directly against a party in a foreign state. They're very closely related.
But what happens here? You've got to distinguish between the person against whom orders are made and the documents in respect of which the person then has to act. And what happens when all the documents and all the transactions to which the documents relate are in England, but it so happens that the person has moved abroad or is a trustee abroad? You're not asking the foreign court to do or make any orders against that person. You're not seeking to take any steps to get documents within that other state. All you're saying is everything is here, but the person happens to be abroad, but the court can make an order.
An order for disclosure against a non-party is not an order against documents.
No, it's against the person.
It's an order against a person.
It would be enforced by contempt proceedings in this country.
It would be enforced by contempt proceedings in this country. It makes no difference. The question, therefore, is whether the court has in personam jurisdiction, to use an unfashionable phrase. That question only, where one is not concerned with the British subject, where special considerations can in some cases arise, we're not concerned with that here. The question is, there is no difference that the documents happen to be here. If an order for disclosure can be made against the solicitors who have control of the documents and the solicitors are within the jurisdiction, then there is no problem. That will be a matter for a subsequent hearing. But the question here is whether the court has personal jurisdiction.
I understand that, but why is it affecting the foreign state? Other than that, the person on whom the application is served is in the state, and the application has to be served in that state when you're dealing with jurisdiction over the person.
It is the long-standing practice of states where evidence is required from a person within a foreign state to follow the letters rogatory process and not to make orders against those persons from within the state seeking the evidence.
You refer to the fact that there's an outstanding issue about whether the order can be made against the trustees, against the solicitors, but presumably your position, which is the reason we're here, is that such an order can't be made and that the trustees have to be joined to the proceedings in order for the claimant to get the documents.
We say that that's exactly right. We say that the documents can only be obtained by by going through the letters rogatory process and making requests for specific documents.
Yeah. Okay.
I will be getting into more detail of all of these principles in a moment, so there will be time for us to explore these issues further. The fourth reason is that there is a well-established process for obtaining evidence, as I've just said, from witnesses in foreign states through the letters rogatory process. It's been developed through the Hague Evidence Convention. There are civil procedure rules setting out how that process works. It would be surprising, and it's a fourth factor going to the construction of Section 34, if Parliament had intended to set up a parallel process. That's a point that is made clearly in the Kellogg, Brown and Root case, which we will look at in due course. And then the fifth reason is that an order for disclosure against a non-party
Is that one that's in the authorities bundle?
I hope so. No, in fact, I'm certain that it is. It's
the Serious Fraud Office.
That's the one.
Yes, sorry, I was yep. That's all right.
The fifth reason is that an order for disclosure is enforceable by contempt, and there are two parts to that. The first is that we say it is contrary to the Comity of Nations, again, to make an order against a mere witness to give evidence or provide documents that is punishable by contempt. And we say it's also an important factor in construing Section 34, that the court will be concerned with the effective enforcement of its orders. And in light of those principles, we say that there are very good reasons to conclude, and it is the right conclusion, that Section 34 is limited in its application to persons within England and Wales. Also, in light of those principles, the House of Lords and the Supreme Court have twice in recent years construed similar, apparently broad and on its face unconstrained powers relating to the obtaining of evidence from persons in foreign states, and concluded that they do not have application outside the jurisdiction. That's the Masry case and the Kellogg-Brandenroot case, which I was hoping to call KBR. So I'd just like to go through those principles in a little bit more detail before looking at those two cases.
Well, before you do, can I just mention two other factors on which, at any rate, I would welcome assistance of both parties. One is that the power to order third-party disclosure is in a section which also is concerned with the making of orders in respect of property. And I wonder whether there is any learning or assistance on whether that applies to property outside the jurisdiction. On the face of it, it seems a bit unlikely that it would, because one would expect the English court to be doing that. But there may be cases or jurisprudence about that. And the second additional point is to do with the legislative history, because these provisions originally came in, both pre-action and third-party disclosure, in 1970, pursuant to the Wynne Committee on Personal Injuries, and were limited to claims for personal injury and death. It was only in the CPR reforms that was removed, and it seems to me that may possibly have a bearing on what was the intended scope of the legislation. And if limited when it first came in, was there anything in either Lord Wolf's report or anything else which shows what the object was in widening it out? Those may prove to be red herrings, but at this stage I'd welcome any assistance you can give us on that.
Thank you. I have made a note of those points. The first point is the presumption against extraterritoriality. Now, the KBR case, and in fact the Masry case indirectly through Bennion, both refer to the statement of Lord Bingham in the Crown on the Application of Alscaini and the Secretary of State for Defence, which is at tab 18 of the authorities bundle. Given that it's been cited by the Supreme Court and by Bennion, it seems to be a good place to start. It's paragraph 11 of the judgment, which is page 258 of the bundle, and page 179 of the report. First of all, Lord Bingham quotes Bennion. I should say Lord Bingham was in the minority in this case, but not on this principled issue, and it's his statement that's been most widely referred to subsequently. Unless the contrary intention appears, Parliament is taken to intend an act to extend to each territory of the United Kingdom, but not to any territory outside of the United Kingdom. That's about extent, not application. And then the author adds, unless the contrary intention appears, an enactment applies to all persons and matters within the territory to which it extends, but not to any other persons and matters. Now,
the difficulty with that is what they were trying to say there is Section 6 of the Human Rights Act, which says you mustn't act incompatibly with Article 2 and 3, applies to soldiers in southern Iraq. It's quite a million miles away. I mean, I understand the general principle, but in terms of application, it's quite a million miles away from the sort of issues we're dealing with here.
Certainly, I do not rely on the application of that principle in Alscaini. It's simply that statement of the general principle has been referred to outside of that context. It's cited in Bennion, it's cited in fact, in the Kbr case, which is far more close to our matters and directly concerns the construction of a power to require a person to give evidence. So I think that, although of course the facts are very far away, the principle is one of general application, albeit that the context does matter. The context of the specific statute, of course, matters, and I will address the court on that point in a moment. There is then the reference to the case of Tomelin endorsing a statement in Maxwell on the interpretation of statutes in the absence, this is again a general principle, in the absence of an intention clearly expressed or to be inferred, either from its language or from the object or subject matter or history of the enactment. The presumption is that Parliament does not design its statutes to operate beyond the territorial limits of the United Kingdom. And then just over the page, at the end of paragraph 11, Lord Bingham says that it refers to a number of cases and concludes that there is such a presumption is not, I think, in doubt. It appears, per Lord Walker in Al Saba above, to have become stronger over the years. Now, it is accepted that the extraterritorial effect of a statute may be found to be implied in the words of the statute, either by its object or its legislative history. But this implication is not something that is easily done. In this regard, may I look quickly at the decision of the Supreme Court. This is tab 25 of the bundle in Cox and Ergo Versicherung, 2014, one appeal cases, 1,379. And I want to refer to paragraph 27, which is page 1393 of the report and page 503 of the bundle. So at the bottom of page 503, perhaps I could just ask you all to read paragraph 27, and then I will skip ahead to paragraph 29.
Do you want us to read 29 as well?
No, just 27.
Uh-huh.
Paragraph 29, I want to skip to halfway, the third sentence I think it is, beginning with implied extraterritorial effect, just about 2 lines above G. Implied extraterritorial effect is certainly possible, and there are a number of examples of it. But in most, if not all cases, it will arise only if, 1, the terms of the legislation cannot effectually be applied, or its purpose cannot effectually be achieved unless it has extraterritorial effect, or 2, the legislation gives effect to a policy so significant in the law of reform that Parliament must be assumed to have intended that policy to apply to any one resorting to an English court, regardless of the law that would otherwise apply.
Again, can I just understand, I understand that you're taking them as general statements, but general statements are often set in a context. What was actually being argued here? This was an English woman whose husband had been killed in Germany by a German car, driven by a German person, and the question was whether the English substantive law of the Fatal Accidents Act applied to accidents abroad.
That's right.
That's the context.
That is the context.
Right, okay, just let me
Yes,
understand.
notwithstanding that German substantive law applied as a conclusion, whether the Fatal Accidents Act nevertheless had some sort of mandatory extraterritorial effect such that
it applies to the German man who'd been driving the car would have to pay the English woman because of his driving in Germany that killed the husband.
Indeed.
Yeah.
And as I say, as you say, I'm only relying on the general principle. That was the speech of Lord Sumption, in that case with whom the other law lords agreed. Lord Mance did have a separate judgment at the end, but on this section of Lord Sumption's judgment, he said that he agreed with his reasoning and conclusions and had nothing to add to those statements of principle.
And then at 32, 33 and 34, is it, Lord Sumption explains why this particular act didn't apply to the man in Germany.
That's right.
Yeah, okay.
So we will come back to look at the that presumption in Masri and in particular in Kbr, which are, as I say, factually much closer to our case. Second reason, as I've said, is that compulsory disclosure is an exercise of sovereignty. The decision of Mr. Justice Hoffman, as he then was in McKinnon and Donaldson, Lufkin and Jenrette Securities Corporation, 1986, Chancery Reports 482, is at tab 8 of the bundle. Now, it's a very interesting case. This was, it really goes to the point that was raised earlier about documents in the jurisdiction. Here it was the opposite situation. The court had personal jurisdiction over the bank, but the documents were outside the jurisdiction. And so it was in many ways a more, as Mrs. Justice Cockrell said in Nix and Emanator, in many ways a more difficult case. And it's explained by principle of self-limiting jurisdiction, as Mr. Justice Hoffman described it. But there are a number of interesting passages in this judgment. I wanted to refer to page 494 of the report, which is page 101 of the bundle. And at the bottom, from around F, having already described this principle, this self-imposed limitation upon the English court making orders for disclosure of documents outside the jurisdiction, even when it has personal jurisdiction over the respondent, he compares that position of a mere witness to certain other parties to litigation. And I think perhaps I could just invite you to read from F to the bottom of the page, just to the end of the sentence over the page. And then going back to C on the previous page, at 494, he says that it seems to me that the subpoenaed order in this case, taking effect in New York, are an infringement of the sovereignty of the United States. And I wasn't going to go to it, but I now recall that it's actually here. It's the previous page from the bottom, just in between G and H, where Mr. Justice Hoffman points out, says, it is perhaps ironic that the most frequent insistence upon this principle by Her Majesty's government has been as a result of its violation by the courts and government agencies of the United States. And he goes on to say, it is all over the page, the government has also objected to demands made upon English companies for the production of documents situated outside the United States and concerned with transactions taking place abroad. It's not exactly the same point because of the specific issues that were at issue in that case, but he's making the point that the English courts and the government have objected to the development of a long-arm jurisdiction in relation to disclosure in support of United States proceedings by the United States courts.
Can I just be clear, because the principle, just before the sentence that you referred to in G, the principle is that a state should refrain from demanding obedience to its sovereign authority by foreigners in respect of their conduct outside the jurisdiction. So that's, as you say here, the bank had an office in England, but they wanted to get them to produce documents in New York.
That's right.
What was the legal instrument giving the power to issue the subpoena, do we have it here? Is it the rules of the Supreme Court, or was it a section of the Act? Because you need to know what those words were, really. Don't worry if we haven't got it.
I think it was the Bankers Book Evidence Act.
Is it Section 7 of the Evidence Act?
It's Section 7, yes.
Okay. Yes, that's at 491E. It says application was made for an ex parte order under Section 7. So we need to look at that act to see how similar it was.
Yes, I'm only making the point that well, I mean, it seems to me that although there is no case that's exactly the same as this case, perhaps we wouldn't be here if there were. The reasoning of Mr. Justice Hoffman here, in relation to the orders to be made against mere witnesses in foreign jurisdictions, is closely analogous to this case. In fact, there isn't a single passage that makes this point, but it seems to me rather implicit in the speech overall, like in the Masri case that we'll come to, that where the prospective respondent is outside the jurisdiction altogether, that would be seen to be a stronger case against an order for disclosure against that person. The difficulty here was that the documents were outside the jurisdiction, but they had in personam jurisdiction, so they could have made an order.
They had jurisdiction, but they declined to exercise.
That's right.
Yes.
Yes.
So this is a case which ultimately turns on discretion. I suppose that Justice Hoffman might have construed Section 7 of the Bankers Books Evidence Act as being limited to bankers' books within the jurisdiction, but he didn't do that. Maybe it wasn't the way it was argued. He dealt with it as a matter of discretion.
Indeed.
Although you can, I think this is what you want to get out of the case, make the general point that it shows that a subpoena is regarded as a sovereign act, and that's part of the background to construing our statutory provision to see what Parliament may or may not have intended.
Exactly that. I will thank you. 2 points. One is that in relation to the construction of the Act, the fact that the respondent was in the jurisdiction probably would have dealt with the construction point, because it's personal order. It could have been made. It would extend to persons within the jurisdiction.
Well, that's why I said he could have construed the Act as being limited to bankers' books within the jurisdiction.
Could have been, but the presumption against extraterritoriality is typically expressed by reference to the object. But I suppose it goes back to the property point.
And one thing I was wondering about in looking at this case, which I haven't had time to look up, is presumably there is nothing in the Protection of Trading Interests Act which deals with disclosure of documents. As I recall, that's more concerned with not giving effect to orders for triple damages. Maybe Mr. Stratton might put that
I'm sure
up
he's
for you.
looking at it immediately.
So, in summary, Mr. O'Leary, exactly what points are you saying we should take from this?
I will go in a moment to the case of Nix Indemnidator. This is a useful starting point because Mrs. Justice Cockrell refers back to it. The point that I would say is that that you should take from this is that an order against a person in a foreign state, that they give disclosure in aid of English proceedings, is an exercise of sovereignty within that foreign state. The position is very different where the respondent is a mere witness from the position where the respondent is a party to proceedings, in the examples that Mr. Justice Hoffman set out. The court should be very slow, is the position Mr. Justice Hoffman takes, in relation to making such orders against persons, or in this case in relation to documents outside the jurisdiction, and that is a powerful factor in the construction of Section 34. That means that it is unlikely that Section 34 has impliedly extraterritorial application.
Thank you. Which authority now?
On that point, it might be helpful just to note very quickly in the middle of 496, page 103 of the bundle, international law generally recognizes the right of a state to regulate the conduct of its own nationals, even outside the jurisdiction, provided that this does not involve disobedience to the local law. Then to Nix and Emma data, which is tab 36 of the bundle. I'll need to pick up my pace a little bit. Paragraph 18. May I assume that I've read this case as being one of the most recent and important? Yes. So I'm going to draw a couple of points out here. This is still on the point about sovereignty. Paragraph 18, so far as sovereignty is concerned, again, it seems to me that the fundamental point is that one has to respect sovereignty. Oddly, the party seeking disclosure in that case sought to rely on Mackinnon as being sort of an exception, saying, well, in there, the documents were outside the jurisdiction. But she says she distinguishes that case. I don't rely on that. I'm just explaining the reference. I would like to jump ahead, though, to paragraph 27, where she says, this application is in essence and acknowledged to be a way around the letter of request regime.
I mean, you've jumped into discretion now, haven't you?
This is very relevant to discretion, but I think it's also very relevant to construction. It goes to really a number of points on construction. One is the scope of sovereignty. One is the fact that there is already... One is my next point about comity. I'm going to go back to paragraphs 23 to 26, which make the point that I've made about that the English court will not make a letter of request in wider terms that it would itself accede to.
Could you just help me understand something that because this is not my area? Is the letter of request the thing that you use when the documents are abroad to get the documents abroad? And another thing is the way in which you serve applications abroad, where you have to send it to the central authority and they issue it because we don't think it right to serve documents abroad. Are they two separate things?
Completely separate things with separate Hague conventions, and we're interested in both of them here.
And would the letter of request document assist on the facts of this case, because the documents are in England? If we sent it to Cyprus and said we want these documents, which are documents in England relating to a transaction in England, would the letter of request provision assist? Would Cyprus make an order against the trustees in Cyprus telling them to give us the documents in England?
That would be a matter for the Cypriot court.
It's left as open-ended as that.
I don't have any submissions to make on what the Cypriot court would do. They would need to be. I do say that they would need to be requests for specific documents.
Well, you make that point
but
in
wouldn't
your...
the Cypriot court say, well, that's very nice of you to ask us to do this, but we aren't going to tell England or Wales what to do about documents in England or Wales? It seems to be the same thing. Somebody will be arguing that it'll be like the United States case, the Mackinnon case. The Cypriots shouldn't be telling us whether or not documents should be disclosed.
No, the point in relation to the United States is that the United States court shouldn't be making orders against English companies, ordering them to give disclosure. The United States should make a letter of request of the English court, and then the English court would consider that, and if appropriate, if it satisfies the conditions, it would make an order against the English company to give disclosure of the relevant document, and they would be provided to the United States court.
Anyway, so you say the Cypriot court could decide to order the trustees to disclose the documents in England, and it'd be a matter for the Cypriot courts
to disclose
if there's a specific request.
Yes.
I suppose we could say, metaphorically, that the documents are in a safe in England, but the key to the safe is in Cyprus, which is the trustees' say-so to open it.
Yes, we could say that. It's certainly in relation to the position
So in
of
other words,
the...
if you want to get the documents, you've got to get them through Cyprus.
That's right, and you need to... The appellants would have to make a disclosure statement and certify that they've given...
And all that assumes, of course, that there can't be an order against Forsters, but leave that on one side.
Entirely. There is... I don't know how much weight is being placed on the idea that the document's in the jurisdiction. We would say very little weight should be given to that in the modern age where if you instruct a law firm, documents... these are electronic copies of documents that were sent to solicitors.
About transactions in England, they instructed English solicitors to advise on transactions in England, and everything happened here. It's not the happenstance that it's a big multinational company and it's on the iCloud.
I'm only talking really about the construction of Section 34 in general terms.
Yeah, but within the context of the facts of this case, and just taking my Lord Justice Lewis's point, it is clearly one that resonated with the judge, because more than once in his judgment he refers to the facts that it is not a matter of chance that the documents are in England.
It may be a factor going to the exercise of the discretion, but not to the construction of Section 34. I wanted to go through paragraphs 27 and 28. In the interest of time, perhaps I could ask you all to read those paragraphs. I think they're relevant to a number of the points that I'm making.
Thank you.
Maybe an appropriate moment to also refer to the supplemental authorities and to the to Mrs. Justice Coppell's book, which is at tab 2, or possibly you've received it separately. This is obviously a book about compelled evidence, not a book about jurisdiction alone. Chapter 4, which we haven't referred to, sets out various procedures for obtaining compelled evidence, including 3117, Norwich Pharmacal Orders, the Bankers Book Act, CPR Part 71. Not all of those have extraterritorial application. We know already CPR Part 71 does not, from the Masri case. We have sent Chapter 5, which is behind the blue tab, at least in my bundle, and there's a short point at paragraph 5. Sorry, I've lost my own note now. 503. The English court can have no direct jurisdiction against the witness abroad so as to compel him to give evidence. It can and will, however, in inappropriate cases, ask a foreign court to do what it can to help. And I won't go to each of them, but the same conclusion is reached by the other leading textbooks on disclosure. Phipson on evidence and Matthews on Mallock on disclosure, same author, same text, both say that the English court cannot directly compel a person abroad to attend the English court or any other court to give evidence, or a non-party abroad to produce documents. That's tab 4 of this bundle, paragraph 2-59. And Hollander on documentary evidence, which is tab 3 of this bundle, paragraph 29-01 says, the English court cannot, therefore, directly compel a person to attend the English court or any other court to give evidence or to produce documents. And so it comments that the letter of request process must be used. While we are still on NICS, I'm taking the point very quickly, because I've already made it. Paragraph 23 refers to Sharman and Sharman, where Lord Justice Wilson made the point that I've already made, that in the context of letters of request, the English court will not send a letter of request to a foreign court in wider scope than the English court it would itself give effect to. do unto others as you would be done by. And she refers then to the similar effect in Sony and Panayotou. And then paragraph 25, may I invite you to read that in the interest of time and moving on? So I say that those paragraphs really support my third principle, along with the McKinnon case that we've looked at in relation to comity and the respect of foreign states, and as a factor in going to the construction of Section 34, that means it's unlikely, without express words, that Parliament would have intended to give the court the power to bypass the letter of request process, and to make orders that the English court would object to if they were made against its subjects. And if they were, even if they were made through the formal letter of request process, would not give effect to.
Do we have the letters of request process in the authorities bundle so we can see what you can actually ask for?
We have at tab 5.
And does this clearly cover requests to somebody in Cyprus vis-a-vis documents in England?
Well, may I come back to you on that, on exactly where that point is to be found?
Yeah. Because there'd have to be an order allowing inspection, wouldn't there, of the documents. So the court in Cyprus would have to make an order against the trustee in Cyprus, requiring them to allow the inspection in England of the documents in England.
That's my understanding, my lord. I'm not sure that it uses the language that we use of disclosure and inspection in the same sense, but certainly the documents are themselves provided. That passage also supports my fourth reason, which is that it would be surprising in the light of the long-standing practice of states to make letters of request and the Hague the Hague Evidence Convention, and the rules and regulations that have been developed around those processes. If Parliament had intended to set up a parallel process, I will make that point good by reference to the Kbr case. That's a point specifically made in the construction of the relevant power in that case. And then the fifth reason I've said is that as a principle of construction, is that the court will often be unable to enforce an order made against a foreign non-party, and if it does so, it will do so through contempt proceedings. There are 2 points.
What was the letter of request procedure in 1970 when these provisions first came in?
Well, the Hague Evidence Convention was also entered into in 1970.
I know, but it wasn't. It was not given effect in this jurisdiction until 1975. I don't know when the UK ratified it or when it came into effect, but if there were letters of requesters at that time, it must have been under some other regime.
I think through the long-standing practice of states was to send letters of request not through a convention. I'm not aware of any previous convention.
My lord, can I help on that? Your lordship has in Ms. Cockrell's book, chapter 5, paragraph 517, deals with the situation where there is no convention.
Sorry, say that reference again.
517. It's supporting what my learned friend says, that the practice of letters of request exists both under the Hague Convention and entirely independently of the Hague Convention as a matter of ordinary diplomatic.
Thank you very much. That's very helpful.
We will go to a passage in Masry from a 1964 Hague lecture by Dr. Mann, where he already at that stage refers to the long-standing practice of states not to enforce through contempt.
So the convention was simply a common procedure for dealing with it, rather than the invention of something new.
Yes.
Yeah. Okay.
So I was talking about enforcement by contempt. There are 2 points. One is the point I was just discussing from Dr. Mann, describing a principle of comity, that states will not order persons in foreign states to give evidence punishable by contempt. And it's a related point. It's not exactly the same point, which is that the English court will be concerned about the enforcement of its orders, and that will often be if the fact that the court would be unable often to enforce an order against a non-party in a foreign state for disclosure is a factor that goes to the disclosure to the construction of Section 34. That's a point we will look at specifically made by Lord Mance in Masry as a matter of construction.
I'm just thinking now, on your point about acts of board, you'd have the service out of the application saying we want the order. You'd have the argument in this country. The order would be made in this country. And before you even get to contempt, you've got to serve the order with a penal notice. So we'd have to serve the order from England to Cyprus saying, you must do this now. And if you don't do it and you ever come to England again, you can be in prison for contempt. And then if they ever did come to England again, it's only then that they would actually this court would be able to enforce the order. Is that how it's going to work?
I think that there would not usually be a penal notice attached to an order under CPR 3117. I think that it would be an order of the court, and if you persistently refuse to comply with an order for disclosure, then the court may find that you're in contempt. It's in that sense that the order would be only enforceable through contempt proceedings.
But I thought you couldn't commit for contempt under Part 81 unless you'd issued a penal notice. There's contempt, there's committal for contempt. Committal is when you're sent to prison for contempt, and I thought you had to have a penal notice. There's a point that might help you, because we've got to send a letter to another country saying if you leave your country, come to our country,
yes, indeed.
then you can go to prison.
Yes, I think that, I don't suggest that there would ever be committal. I think it would be very unlikely that a court would attach a penal notice to a 3117 order. I think it's unheard of. And I think it's highly unlikely that there would be committal for contempt. This is an order that is going to not bite very hard if the jurisdiction exists. And we say, again, that's another factor that goes to the construction. And as I say, we will look at that in Masry. Before we look at Masry and KBR, I must keep going. It may be worth just making one other observation, because there is some discussion in the cases, in particular in Masry, of Section 36. Section 34 and Section 36 are the two different sections of the Senior Courts Act that give the court the jurisdiction to make orders against non-parties, requiring them to, in one way or another, to give evidence in support of English proceedings. And when we're looking at those, it's instructive to compare Section 34 to Section 36, and it's a convenient point to do that. They are in tab 2 of the bundle. Section 34 is at page 9 of the bundle. It says nothing about anything happening outside the jurisdiction. Section 36, I don't rely on any words, it's the absence of words in Section 34 I'm interested in. Section 36, by contrast, is at page 16 to 17 of the bundle. And in subsection 1, at the end of that section, it provides that the court may command the witness to attend the trial wherever he shall be within the United Kingdom, and the service of any such writ in any part of the United Kingdom shall be as valid and effectual for all purposes as if it had been served within the jurisdiction of the High Court. And then in subsection 3 it goes on to explain what happens if the person served with the writ does not appear, and that the result is that the High Court may transmit a certificate of default to the relevant Scottish or Northern Irish courts. Now, that is very clear words expanding the scope of the power to to issue a subpoena to jurisdictions outside of England and Wales. There is no such similar wording as to how that suggests that Section 34 has any application outside of England and Wales. As a matter, I can find the provision that it's actually set out in the judgment that says that the extent of Section 34, in other words, the territory in which it is in force, where its law is limited to England and Wales, and that's how the presumption of extraterritoriality works, by reference to the extent. So it's presumed that the application of the section is the same as the extent, unless there is clear wording to the contrary. That's another fact. That is, we say, of some weight in construing Section 34, that it does not contain the expansive language that Section 36 does.
Or the enforcement mechanism. It's both the language and the enforcement mechanism.
Indeed.
Yeah.
In fact, although in some ways Section 36 is a more onerous process in that it can require a person physically to come and give evidence, it can also be used to obtain documents. And in some ways, Section 34 is much wider, because Section 36, like the Hague Convention or letters rogatory process, is typically done by reference to specific documents and can only, in fact, Section 36 may only be used by reference to specific documents, whereas Section 34, on its face, refers to a test of relevance, which is obviously much broader. So if Section 34 were to have global effect, it would allow orders to be made anywhere in the world, and also within Scotland and Northern Ireland, ordering people to give documents of a much wider class than can be obtained through the Section 36 process. So turning to two cases, I'm just being reminded to keep an eye on the clock for the transcriber's break.
Well, when you know where you want to go and how you want to do it, when there's a convenient time for you, stop.
Thank you very much, my lady. I'd now like to look at the two big cases of Masri and Kbr. First of all, Masri is at tab 20 of the bundle. The question in Masri was about the construction of CPR Part 71. CPR Part 71 allows the court to make an order for requiring an officer of a corporate judgment creditor to attend to be examined in relation to the assets of the judgment creditor. The question was whether or not an order could be made against an officer outside where that person is outside the jurisdiction, whether CPR Rule 71 has extraterritorial application. And the case, much of the discussion and argument surrounds the fact that the case sat between two previous decisions, a decision of the Court of Appeal. Some of this is picked up at around paragraphs 19 and 20 on page 360 of the bundle, which is page 138 of the report. So there's it really is necessary to set this out, not because it's important, but because it gives context to what the court was considering. There was, on the one hand, the decision of the Court of Appeal in Inri Tucker, bankrupt, 1990 Chancery 148. This is referred to at paragraph 19 at C, where the Court of Appeal set aside an order obtained by a trustee in bankruptcy for the examination under Section 25(1) of the Bankruptcy Act. That gave the court power to summon before it for examination any person whom the court may deem capable of giving information respecting the debtor, his dealings or property, and to require him to produce relevant documents. And at E, there is a passage from the judgment of Lord Justice Dillon. In the light of the accepted practice of nations and comity in the field of international law and international relations, eyebrows might be raised at the notion that Parliament had, in 1914 or 1883, given jurisdiction to any bankruptcy court, which might well be a county court, to summon anyone in the world before it to be examined and produce documents. On the other hand, there was, at paragraph 20, see, Mr. Rabinovich relied upon the case of In re Seagull Manufacturing Company Limited, 1993, Chancery 345. That concerns section 133 of the Insolvency Act, which authorized the public examination of, effectively, persons, including officers of the company. So this case sat between those because in terms of the object of the power, it's closer to the latter case. Part 71 is concerned with officers of the company and not with any witnesses. On the other hand, Lord Mance goes on to point out that the insolvency winding up processes are important, have universal application and have public importance, and that private civil litigation is quite different. So I'll come to the conclusions in a moment. First of all, I'd like to pick up, because it's relevant to another point I've made. Well, actually, I'll come back to those points. I'll go to the conclusions first. I'll come back to the principles. At page 362 of the bundle, around letter C, he makes the point that Lord Mance makes the point that I've just made, setting out that unlike a winding up process, private civil litigation is different. A fair and efficient legal system is, of course, a cornerstone of the rule of law, and it can also be said that there is a public interest in a court getting to the bottom of litigation and ensuring that parties have the means of obtaining full information to enable it to do so. Yet the parties have no right to ask the court to summon witnesses from abroad for that purpose. While the judgment crystallizes rights and establishes an unsuccessful defendant's liability, the court is still acting in aid of private rights after judgment, and it may be questioned whether, in terms of public interest, there is a very great difference between the importance of evidence for the trial of liability and quantum and for the enforcement of a judgment. And then his further conclusion is paragraph 26. Could I invite you to read paragraph 26?
Thank you.
So the House of Lords concluded that Part 71, although it doesn't contain any express wording about its application, did not have extraterritorial application, and that an order requiring an officer of a corporate judgment credited to attend court could only be made where the officer was within the jurisdiction. In terms of, there are a few passive points of general principle that I'd just like to pick up. We don't need, in paragraph 10, there's the reference to Bennion, referring to Isle Skyning. We've already looked at that, just setting out the presumption against extraterritoriality. And then at paragraph 12, at the top of page 357 of the bundle, there's the passage that I mentioned previously from the lecture of Dr. Mann, the Hague lecture. Nor is a state entitled to enforce the attendance of a foreign witness before its own tribunals by threatening him with penalties in case of non-compliance. There is, it is true, no objection to a state by lawful means inviting or perhaps requiring a foreign witness to appear for the purpose of giving evidence, but the foreign witness is under no duty to comply and to impose penalties upon him and to enforce them either against his property or against him personally on the occasion of a future visit constitutes an excessive criminal jurisdiction and runs contrary to the practice of states in regard to the taking of evidence as it has developed over a long period of time. And that ties in then to another point which is made the converse point, which I mentioned, at paragraph 22, Lord Mance is discussing the reasoning of Mr. Justice Peter Gibson in the Seagull case, which he didn't follow, although he didn't overturn it.
But just hold on. The passage from Dr. Mann is in the context of the construction of the rulemaking power in the Civil Procedure Act, where Lord Mance concludes that that is wide enough to allow rules having extraterritorial effect. It's only when he gets to the construction of the particular rule, CPR 71, that he concludes that although the Rule Committee had power to make a wider rule, in fact they hadn't done so.
Yes, that's everything that your Lordship says is entirely correct. I've referred to it because I think it's an important principle going to construction, and it ties in to the question of enforcement.
But if the rulemaking power is broad enough to cover applications in relation to persons outside England and Wales, and if Section 34 says it's in accordance with rules made, and i.e. the scope of the power in Section 34 is linked to the rulemaking power, that begins to sound as if, as a matter of jurisdiction, Section 34 did contemplate that rules might be made dealing with witnesses or persons abroad. You may not exercise them if the documents are abroad, but that's a different issue.
I'm not sure one can put the A and B together there.
Mm-hmm.
The rulemaking power is very wide,
Yeah.
but the point that Lord Mance is making in paragraph 14 about the rulemaking power is that in relation to a witness summons, there is already Section 36. Section 36 is clearly limited in territorial scope, as we've just seen, to England, to the United Kingdom. This is paragraph 14, page 358 of the bundle, around letter B.
Yeah. But we're not dealing with Section 36,
No.
we're dealing with 34.
No,
And
of
if you look
course.
at the words of 34, and we haven't actually looked at the words of Section 34 yet, one argument put against you is that Section 34 says that, in effect, the rules will prescribe the circumstances. Now, if the rulemaking power didn't operate extraterritorially, that would be the end of the scope of Section 34. But if the rulemaking powers can operate extraterritorially, and if Section 34 ties itself to the rulemaking power, the argument against you is that, in effect, if the rules have, on their proper construction, covered a situation where, as a matter of jurisdiction, you could send an application to a person outside the United Kingdom, that's the proper construction of Section 34.
Yes, I understand. I am addressing that point.
Ah, right.
The point that Lord Mance is making in relation to Section 36 is that, as a matter of construction of Section 36, it has limited jurisdictional application.
Yeah.
In those circumstances, that precludes the possibility of a rule requiring an ordinary witness outside the jurisdiction to attend for examination within the jurisdiction. So the first point Lord Mance is making is that, given the limited territorial application of Section 36, the rulemaking power is not unlimited. The rulemaking committee could not...
In relation to examining witnesses abroad.
In relation to requiring a person outside the jurisdiction
abroad to come to
attend.
the jurisdiction, yeah.
That's the subject matter of Section 36.
Yeah.
But the point is that, first of all, he construes Section 36, and then he says that the rulemaking committee powers are not broad enough to outflank the territorial scope of the rules that have been enacted. So first of all, one has to one doesn't start with the rulemaking power to construe Section 36. One starts by construing Section 36, and that sets a limit on the rulemaking power. That would not, he said, in principle, prevent the rulemaking authority from enacting very specific rules relating to the examination of an officer abroad of a company against which a judgment has been given within the jurisdiction. So, because that's not something that's dealt with by Section 36, that's a very specific provision, so the rulemaking power can take effect. So my point is that what we have Section 34, that sets out, that as a matter of the construction of Section 34, is the first question. If as a matter of construction of Section 34, in light of the principles I've referred to, Section 34 does not have extraterritorial application, then the rulemaking power isn't wide enough. The general rulemaking power isn't wide enough to create a rule giving the court such a power. That's the logic of Lord Mans.
Yes.
I will
the whole
come to
question is, if it's the other way around, and if Section 34 describes the scope on any limitations of the rules by reference to what the rules provide, then that's the answer.
Well,
and that turns on the wording of 34.2.
Well, that is a construction of what is being set out in the narrow reference to rules in Section 34. I would suggest that is the construction of that is subject to exactly the same principles of construction I've already referred to. You can't combine the fact that if there weren't a provision in the Senior Courts Act, the rule-making power is very wide, with the fact that Section 34 refers to the idea that rules might be made and say, well, hey presto, therefore the rules could be made applying that wherever you like. If it's right that the application of Section 34 is limited to the territory, the reference to the possibility that rules might be made should be limited in the same way. But if it were not so, even if I'm wrong, let's say that what that means is that the rules might say, actually, we've decided that now that Section 34 applications can be made outside the jurisdiction. There is no such rule. The CPR 3117 sets out the rules that are referred to in Section 34. The CPR 3117, they are the rules that set out the circumstances in which the court may make an order under Section 34 of the Senior Courts Act. CPR Rule 3117 does not say anything about orders being made against persons outside the jurisdiction. The construction of CPR 3117 would be subject to exactly the same principles of construction as I've referred to, and it would, following Masry, I would submit that the same conclusion would be reached, that it's not, even if Section 34, the reference to rulemaking power, were considered broad enough to allow such rules to be created, they haven't been.
Can I ask you to look at 34.2, just so
Of course.
I'm not inadvertently putting the question unclearly. 34.2, on the application, in accordance with rules of court, the High Court shall, in such circumstances as may be specified in the rules, and what I'm suggesting is that, on one interpretation, has this section left the scope of the rules and whether or not they're going to be extraterritorial or limited to the rules. Now, if the rule-making power was limited and couldn't make extraterritorial rules, then that would be the answer. But if the rules could be extraterritorial, the question as to whether or not Section 34.2 applies extraterritorially is itself, it's circular, but is itself left to the rules. That's what I'm putting to you. I haven't put it clearly.
Yes, my lord, no, I understand the point. The question is that to be construed as allowing the Rules Committee to massively expand the territorial application?
That's the question. Is there a
is,
prior limitation subject to the rules subject to the presumption against territoriality on the application in accordance with the rules of court, brackets, as long as those don't act extraterritoriality, close brackets, in such circumstances as may be specified in the rules, brackets, so long as they only apply to England and Wales, close brackets. That's what you're saying the rules should be understood, the power should be understood as being.
My primary submission is that there is a case, it's not in the authorities bundle, we can bring copies at lunchtime. It's a decision of the House of Lords in Holmes and Bangladesh Beeman Corporation, which considered a broad power to make regulations in relation to air carriage. It was unlimited in the scope of the words. The House of Lords said that that power was itself limited to the jurisdiction. It didn't allow such rules to be made in relation to matters outside the jurisdiction. So it's a very similar thing where rules there's a power to make rules, and it's construed with a presumption against extraterritoriality. But the other point I've already made is that the rules haven't gone that far. we're not concerned with a situation where such a rule has been developed, where someone has purported to make a rule, allowing a Section 34 application to be made outside the jurisdiction. There's a hint in the judgment that Gateway 20 itself is somehow a rule that expands the territorial scope of Section 34, but it doesn't do that. It refers back on its own face to whether or not Section 34 allows proceedings to be brought outside the jurisdiction.
All right, Mr. Sorry, no, please, you go.
I say so. If I understood your essential answer to my lord is that if Section 34 does effectively leave it to the Rules Committee to decide whether to make an extraterritorial rule, the answer is that they haven't done so because the principle of territoriality has to apply to CPR 3117 just as it did to CPR 71. Is that the essence of your response, whether it's right or not? But have I understood it?
Yes, I think that there's CPR 3117 doesn't look like it's trying to expand the territorial scope at all. And if there were any suggestion that 3117 were impliedly to have had that effect, then following the reasoning in Masry, we would say it should be construed as not having purported to extend Section 34 to people outside the jurisdiction. Of course, my principal submission is that that wouldn't be a permissible exercise of the rule-making power. That the rule-making power is covered by Section 34, and the references to "in such circumstances as may be set out in the rules" is to be read as itself, as my lord says, limited to rules against persons, applications against persons within England and Wales.
Mr. O'Leary, I am conscious that when I spoke saying take your own time, it was 20 minutes ago.
Yes, I was just going to say I think that would be a convenient moment.
All right, 10 minutes and we will come back in just after midday. Would you like to do a rain check, Mr. O'Leary, as to where you are and how much time you need?
Thank you very much.
Yes.
All right. You're going to have to make the pace up.
Totally.
You've got to be done by 1.
Understood. Totally.
Sure.
Yeah, let's go outside. That's fine.
Right, we're going to get to the section then, Mr. O'Leary.
We can look at it, my lady.
No, but, you know, we're going to have to get to it sooner rather than
No,
later.
I'm very conscious of time. My lady, I have very little to say about the section itself. It doesn't have any words that tell us whether or not it has extraterritorial scope. The significance is that it allows the court to make an order against a mere witness, requiring that person to give disclosure in aid of English proceedings. The principles that I have referred to suggest that such a rule should be construed narrowly in terms of territorial application and to be limited to the jurisdiction. There is nothing else in the text that I rely upon in relation to that conclusion, save by contrast with Section 36, as I've already set out. I was just finishing off Masry, and there was the last point I wanted to make in Masry was just at the bottom of page 361. Lord Mance disagreed with Mr. Justice Peter Gibson, and Mr. Justice Peter Gibson had said that the court wasn't concerned with whether or not an order could be enforced, and Lord Mance said he had some difficulty with that, and that making an order against a person abroad was a different matter to making a mandatory order against someone abroad with no personal connection with England for attendance to be examined as a witness. Impracticality of enforcement is a factor of greater relevance than Mr. Justice Peter Gibson's word suggests. It is in particular a relevant factor when considering whether CPR Part 71 covers officers abroad. So we say that it is a very relevant factor to the question of construction, whether or not an order against a foreign person could be enforced. And Parliament may well have been reluctant to, rightly be reluctant to make such an order that couldn't be enforced, also to give the court the power to make such an order, and that, as he says, is a factor that is particularly relevant to construction. The other important case, and I'll have to take it very quickly, is the Kbr case. It is, it really does track these points of reasoning that I've been setting out. So we'll have to just take it quickly. It's I've lost the bundle reference now.
34.
34. Thank you very much. So that concerned a power given to the Directorate General of the SFO, requiring a person to give evidence or to produce documents. I'd like to really focus on that is, I hope, much closer to our facts, although there is the point that Mr. Justice Jacobs made that it doesn't involve the court's exercise of discretion. Subject to that, points of construction are very similar. I'm going to take the court through the key passages. I'm not sure we'll have time to go through them all in detail at this stage, but I would invite the court to consider these passages. Paragraphs 21 to 22 is not so significant, but I would just note the reference to Al-Skyni again, and the full passage that we looked at from the judgment of Lord Bingham. Then, more significantly, paragraph 24, an explanation of the presumption against extraterritoriality and its connection to the relations between states and to comity. And at paragraph 25, this discussion continues and says that the limits of international law are difficult, and so the presumption in domestic law is more extensive and reflects the usages of states acting out of mutual respect, and no doubt the expectation of reciprocal advantage. Over the page at paragraph 28, Sir James Eadie QC, for the SFO, made similar arguments to some of those that have been made here.
Again, I don't want to be difficult, but you've got to look at 27, and that takes you right back to the words. You've got to always look at the words of the section. The section is at 14. The director may, by notice in writing, require the person under investigation or any other person to produce at such place as may be specified in the notice, blah, 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 blah. And at 27, the question is said to be there whether Parliament intended to confer on the SFO power to compel a foreign company to produce documents held abroad. So they've interpreted the section presumably to say you can't do it for foreign documents held abroad. That's what this was all about.
Yes, my lord.
The words are different.
They are different. It's closer to our facts, but
Yes.
they are not the same facts. And it isn't the same provision. But the approach that the court took to construction is, I would respectfully submit, nevertheless instructive. And these are much closer than the Alskyne case. There isn't, as I say, I'm afraid, a case exactly on point. As I've showed the court, the textbooks all agree that there is no such jurisdiction, notwithstanding Section 34 and CPR 3117, and I'm trying to make that good by reference to general principles of construction. So, Sir James Eadie pointed out the breadth of the provisions, and that there was no limitation as to in the wording of the power. But Lord Lloyd Jones says in the middle of paragraph 28 that when legislation is intended to have extraterritorial effect, Parliament frequently makes express provision to that effect. And then at the end of that paragraph, the more exorbitant the jurisdiction, the more is likely to be required of the statutory provisions in order to rebut the presumption against extraterritorial effect. So that brings my submissions together in the fact that we have this strong point about sovereignty. We have this strong point about comity. We have this fact that there is already a process in place, and the long-standing practice of states is to use the letters rogatory process. And in light of that, a power that bypassed all of that and allowed the court to make orders against persons outside the jurisdiction would be particularly exorbitant in that context. And so it's all the more likely that if Parliament intended Section 34 to have that effect, express wording would have been used. It's much less likely that such wording is to be implied. And then at paragraph 29, the court again makes the point about the Supreme Court, Lord Lloyd Jones, with whom the others agreed, said impracticality of enforcement is particularly relevant consideration when determining whether a statutory provision has extraterritorial scope. So again, making the same point that it goes to construction. Then there's a long consideration about the legislative history and the context and the fact that there is a parallel system in place by which documents can be obtained and evidence can be obtained, not the letters rogatory process, a different process in this context, but the Criminal Justice International Cooperation Act, for example. And then at paragraph 45, Lord Lloyd Jones discusses this, and from the third sentence, well, he says, it can be seen that successive acts of Parliament have developed the structures in domestic law which permit the United Kingdom to participate in international systems of mutual legal assistance in relation to both criminal proceedings and investigations. Of critical importance to the functioning of this international system are the safeguards and protections enacted by the legislation, including the regulation of the uses to which documentary evidence might be put and provision for its return. These provisions are fundamental to the mutual respect and comity on which the system is founded. It is, to my mind, inherently improbable that Parliament should have refined this machinery as it did, while intending to leave in place a parallel system for obtaining evidence from abroad which could operate on the unilateral demand of the SFO, without any recourse to the courts or authorities of the state where the evidence was located. I concede located, but we are concerned in our case with a personal jurisdiction, and it's the witness's location that really matters, without the protection of any of the safeguards put in place under the scheme of mutual legal assistance. And I say that that principle applies directly here. It's exactly the same. We have this system set up. That is the long-standing practice of states is to use that system. It would be Parliament has. There are rules in the CPR telling you how you go about making a letter of request or engaging with the Hague Evidence Convention. It would be surprising if Parliament intended Section 34 to be an easy way around all of that and to be, in effect, a parallel process.
Well, it's critical to your submission, isn't it, that It is the witness's location that really matters, which is
Critical.
what you just said.
Yes.
I mean, if you're right about that, then all of this extraterritoriality comes into play. If what matters is the location of the documents, then there is less of a problem, or there's no problem, and the question therefore is whether one can construe either Section 34 or CPR 3117 as being concerned with documents here, even if the people who have control of those documents may be abroad. And it might be said, I suppose, a bit like Miss Justice Hoffman, that if you bring your documents here, you play by the rules of the game here.
The order that would be made, the order that is sought, we could look at it, but it's standard order under Section 34, is a personal order. It is an order that a person, in this case the appellants, give jurisdiction. That involves a process of identifying relevant documents, stating that they exist, permitting inspection of them, and certifying that the process is being complied with. That's all personal. It is not an order made to go and seize documents. It doesn't relate to the somehow property in ethereal electronic documents. It is an order sought against my clients, personally. And that is what an order allows. It is an order against a person who is not a party to proceeding. It doesn't relate to documents as things.
I'm just looking at 34.2. The court would have the power to order a person.
And it orders him to produce such of those documents. So it contemplates that he would physically do it or call some other person so to do.
Yes.
So if the court made an order saying you, Mr. Trustee, must produce the documents, and they refused, the solicitors would still have to have the instruction, as my lord put it, they would still need to get the key from the trustees, and the trustees would say, no, I'm not giving you the keys. You imprison me if you can, but I'm not giving you the keys.
That analogy of the key, I think, is limited really to the question whether an order should be made against the trustees. It isn't stating that there is actually a key, and it will be a matter for this next application whether or not an order can be made.
But if the trustee said, don't you dare, solicitors, don't you dare let him see that file, the solicitors couldn't do it.
Well, that will be a factor that the court will consider in deciding whether or not an order can be made against solicitors, ordering them to give disclosure of documents.
That's
that
a
are
separate
really their
issue,
clients'
but
documents.
as against the trustees,
Yes.
if there's an order against the trustees and the trustees say no, the solicitors are stuck, subject to your second point about the solicitors. It's not just automatic. There wouldn't be, it's not the document, it's got to be the mind of the trustee in Cyprus has got to agree to the compliance with the order.
Insofar as the order is made against the trustees?
Yeah.
Yes. But if the order is made against the solicitors, then...
But that's separate,
That's a
we're not
different
dealing
point.
with that, yes.
But that goes... No, please.
So this section was originally about personal injuries. And,
Yes, it was.
So suppose you had a case where a doctor examines a patient in England. He's a doctor practicing here, but then he retires and goes to live in Spain and leaves all his documents behind. And those documents turn out to be critical to a personal injury claim which the patient wants to bring. Documents inaccessible because he's in Spain.
I wouldn't want to rule that out altogether because there are a lot of cases that consider the different treatment of British subjects abroad.
No, he's a foreign doctor who came to work
A
here.
foreign doctor who worked here briefly. He's a Spanish. Fine. Yes, in that case, in that case, well, I suppose in that case the doctor would be a party to the proceedings. So there's no issue. We're back into the dispute.
No, it's a claim against somebody else, but,
Okay.
but the doctor's medical records, or the patient's medical records rather, are critical to the claim.
Yes. Well, if in those, it would depend. We would have to know the facts because the nuances of where the documents were and who had control over them may lead to different conclusions. But insofar as an order was sought against the doctor, and the doctor has no presence within the jurisdiction, notwithstanding that the documents are here, then yeah, that's absolutely right. The court would need to go through the letters rogatory process or the Hague Evidence Convention to seek evidence from that doctor.
Okay, thank you.
And as I say, these policy points cut both ways because I do say it's relevant in terms of the construction that documents are held electronically all over the world. If you instruct a law firm on construction, those documents may be accessible and therefore physically come into the location of places also all over the world. The location of documents can be incredibly arbitrary in the modern world. And that's why so that really does go the other way. The location of documents is neither here nor there. What matters is the location of the witness who's being ordered to give disclosure. I must quickly go through, I must move on. I think that we have discussed the judge's point about the scope of the rulemaking power, so I won't revisit that.
Are you going to deal with 31.17?
We can
Wording
look.
of it? No, I just want to know which
No,
way
I'm
you're
not
going.
planning on looking at 3117. I said 3117 does not purport to expand the application of Section 34 outside the jurisdiction. It sets out the procedure that must be followed when you wish to apply for an order under Section 34. It doesn't tell us anything about the territorial application of the Section 34 order.
Where did the power to make Rule 3117 come from then? Is it derived from Section 34 or?
Or the general rulemaking power.
Okay.
I don't know. I suspect it's probably the rulemaking power,
Yeah.
not Section 34 itself. Section 34, however, sort of tees up the fact that
They will matter, yeah.
rules will be made. So then there's this separate. So we say that applying those principles of construction, particularly the presumption against extra territoriality, but the other principles that I've set out, we say it's tolerably clear that one reaches the conclusion that Section 34 does not have extraterritorial application. It does not allow proceedings to be brought, or does not allow an order to be made, more precisely, against a person outside the jurisdiction. It is limited to persons in England and Wales. And so we say the textbooks have it right. There is this separate question about the gateway. What does the gateway require? What is the gateway doing? The gateway allows a claim form to be served outside the jurisdiction, where a claim is made under an enactment that allows proceedings to be brought. And it's the word proceedings that has particularly caught the attention of the commentators and the courts. There is a prior question about the meaning of claim. There's a separate question about the meaning, whether this is a claim. I can take the claim point quite quickly. The claim is defined, as I'm sure you will have seen, in Rule 6.2c. It's a non-exhaustive definition, but it does not, on its terms, extend as far as our Section 34 orders. It says, a claim includes a petition and any application made before action, or to commence proceedings, and claim form, claimant, and defendant to be construed accordingly. it's very important, I think, to note the distinction there, that there are two types of application contemplated. One is an action, one is an application made before action, like pre-action disclosure. The other is an application to commence proceedings. And the point has been made by my learned friend that there are sometimes proceedings can be commenced by application. But they are different, they are not the same. So there is not all applications commence proceedings. Not all applications that are claims.
Doesn't it just mean the thing that starts the legal ball rolling?
It depends on what one means by starts the legal ball rolling. I think
you're going to court to get an order. Proceedings covers things which occur in a court as opposed to other things. A claim is that document which institutes the request for those proceedings to be activated, resulting in an order of the court.
Yeah. I suppose the natural meaning of a claim is typically something that engages the jurisdiction of the court to determine substantive rights between the parties. That's the natural...
Or procedural rights. You must give me your documents.
Well, no, I wouldn't say that that's typically called a claim at all. I would say that that's typically called an application within a claim or within proceedings. In terms of the general usage of the language within the procedural rules, a claim, an application is not... A procedural application to extend time or obtain disclosure or anything like that that's ancillary to the process is not a claim at all in the ordinary language. It's clearly expanded here for the purposes of Part 6, the word claim. The point that I was making, I just want to make sure it's noted, is that not all applications that are claims are applications to commence proceedings. That's implicit in the definition there. An application may be made before action, and even though it's not an action to commence proceedings, it may still be a claim. So obviously, an application for pre-action disclosure is a claim. We would say, notwithstanding that it isn't an application to commence proceedings. Really, both sides agree that the meaning of these words, of the word proceedings, is to be given its neutral, or neutral construction. That's said by the Court of Appeal in Erexum, and I don't say anything contrary to that. I say that the natural meaning of proceedings is the single set of proceedings. In this case, it's the wider proceedings within which this application is proposed to be made. And in fact, that language is reflected in the language of Section 34. It gives the court a power to make an order against a party who is not party to the proceedings. The proceedings, and the claim is the claim brought by Mr. Gorbachev against Mr. Guriev. The proceedings are those proceedings. And that is the natural meaning of those words. And that is the view of Mr. Honda. That was the conclusion reached by Mrs. Justice Cockrell. That was the conclusion in obiter of the majority of the Court of Appeal in the AES case, where Lord Justices Wilson and Stanley Burnton both considered this specific gateway and concluded that proceedings required more than a particular remedy within wider substantive proceedings whose underlying legal basis is to be found elsewhere. Lord Justice Rick suggested that was arguable, and the other two said that was patently correct. So Mr. Justice Jacobs did not follow those previous authorities and comments because he felt bound to follow the judgment of Mrs. Catherine Newman QC in EDNF Mann Capital Markets LLP and OBEX Securities LLC, which is 2017 EWHC 2965, and we will look at that. He said he felt bound to follow that unless he was convinced it was wrong. And we say, first of all, he wasn't following her reasoning. He was significantly expanding it to a different context. And in any event, it is wrong. So, as I've said, it's obvious, and the first limb of Catherine Newman QC's reasoning was that, well, pre-action disclosure is a claim. Fine. And then she distinguishes the position in relation. She finds that it's not like, she doesn't follow AES. She doesn't follow the conclusion of the Court of Appeal in AES. She says that unlike an anti-suit injunction, application for pre-action disclosure may be the end of may be the end of it all. There may never be anything else that started, and so it may end up being freestanding. Whereas she says, unlike a pre-action injunction, where the applicant will be required to commence substantive proceedings. So even if that's right, I'll come back to why it's not right. Even if it's right, it has no application here. The reasoning doesn't apply here. So Mr. Justice Jacobs was wrong to say he was bound to follow it. First of all, I say that an application for disclosure against a non-party is not a claim. It doesn't fall within the definition in 6.2, unlike pre-action disclosure, which clearly does. Secondly, the reasoning by which Catherine Newman QC distinguished AES, the reasoning in AES, was that pre-action disclosure application and order may be an entire process, effectively, freestanding, that never is related to anything else. Unlike that, an order under Section 34 can only be made when there are already existing proceedings. It does not allow proceedings to be brought. You need proceedings in order to make such an order. It doesn't allow a process, the process to be commenced unless the process has already been commenced. There is another important distinction with pre-action disclosure, which is that pre-action disclosure can only be made against a prospective party, not against a non-party who is a mere witness. And that ties back into the passage of Mr. Justice Hoffman in McKinnon that drew a distinction between someone who is bound up by reasons of the ordinary principles of jurisdiction in the English court, and the English court could, on that basis, be taking jurisdiction over them, unlike a mere witness who is not in that game. They're merely being brought in to assist the court in its process. And so there are three reasons why we say the judge was wrong to consider that he was bound to follow OBEX, because the reasoning just doesn't apply to an order under Section 34. And we submit that it's Mrs. Justice Cockrell was right. She said that ED&F Man was a different case and a different rule, and that I certainly do not regard ED&F Man as being any sound basis for saying that Gateway 20 provides a gateway for applications such as this. That's paragraph 17 of her judgment. We say that reasoning is exactly right. And even in any event, we say there are good reasons to think that OBEX was wrongly decided. Mr. Hollander trenchantly criticises the decision. That's in the bundles. I won't go to it, but he says it's clearly wrong. He says that the whole point of pre-action disclosure is to hope that proceedings will never have to be commenced. And that it isn't proceedings. A pre-action disclosure application itself does not constitute proceedings. There's also in the bundle there's the decision of Claimant Energy Partners. I won't go to that either, but it is tab 27. Again, that's an over to point, but Mr. Justice Blair said that was concerned with pre-action disclosure, and Mr. Justice Blair said he had considerable doubts as to whether it was possible to serve an application for pre-action disclosure outside the jurisdiction. That case was not drawn to Catherine Newman QC's attention, and we say that
that single paragraph where he doesn't decide the point seems to me to be an example of oversightation of authority.
Thank you, my lord. I would refer back though to the distinction drawn in the definition of claim itself in CPR 6.2. A claim is can include an application made before action or an application that commences proceedings. Those are two different types of application, and we would say an application for pre-action disclosure is clearly an application made before action, but not an application.
What word would you use to describe the events from the moment when they arrive in court until the judge gave his order about whether or not matters should be disclosed?
I'm sorry, my lord, I don't have the point.
Assuming an application has been issued under Section 34, I've not quoted a claim, and assuming a judge comes into the room and you've got people dressed like you were dressed sitting in front of him and telling him or her what to do, and then he issues an order at the end, what word would you use to describe the events in that room?
I would say that it is an application within proceedings.
The hearing of an application.
Yes, the hearing of an application. Section 34 gives the court the power to make an order against a non-party. It does not allow proceedings to be commenced. That takes me to the second ground of appeal. I think we're now doing much better for time. Second ground of appeal is concerned with the discretion. In Nix and Demodata, Mrs. Justice Cockerell held that there was no jurisdiction to commit service out, but in any event, she said she would have refused permission on the basis the court would otherwise be plainly trespassing on the letter of request regime. That's paragraph 24 of her judgment. We've looked at the relevant passages where she emphasised that between parties to the evidence convention, the letter of request regime is the proper, courteous, respectful method of obtaining evidence within a foreign jurisdiction from a foreign party.
I wonder whether all of this goes to the discretion to make an order under CPR 3117. The discretion which is relevant at this stage is the discretion whether the proceedings, if you'll allow me to use that word for the moment, should be dealt with here or elsewhere. And if the claimant gets over the jurisdictional question, the issue is whether the order for third-party disclosure relevant to English proceedings should be made, and how can anywhere other than England be the sensible place in which to decide that question. All the stuff about whether the order cuts across the Hague Convention from a discretion point of view should be at the next stage, shouldn't it?
No, my lord. It is the act of serving a person in the foreign state is already an engagement of the English court's jurisdiction within that state, is already a sovereign act which suggests that the English court is contemplating making an order for disclosure against that person, which we would say should never be made as a matter of discretion at that stage as well, if it ever got to that stage.
But I thought you could always make applications against anybody else in another state, but what you did was you used this process where you send it to the authorities and they hand it on. That's why I asked you earlier on whether there was a difference between an order under the letter of request and the issuing of a service out of the jurisdiction of an application. An order requiring a person living abroad to produce documents in the United Kingdom is one thing. The service of an application by which that issue will be determined seems to be a different thing.
This is that I completely accept that distinction, and it's an important distinction, and both of those things are very involve the exercise of sovereignty. However, they are combined when what is being contemplated is disclosure.
But when would you ever have an application served outside this jurisdiction on your analysis if sending an application to France or Germany or whatever involves an interference with the sovereignty of a foreign state? You'd never do it.
Well, you do it all the time when it's a claim. When there's a claim where England is the proper jurisdiction, it's complete. It's right to then serve that process on the person in the foreign state in accordance with the Hague Service Convention, if England and if that state is a party to that convention, or otherwise according to whatever process one must follow. So there are separate questions there, but there's nothing objectionable at all about serving a claim form through that process where one is concerned with a claim where the English court is the proper court to determine that claim.
Well, England is the proper court for determining the proceedings here. If there are separate proceedings 2, which is the application for the Section 34 order, just as they must be able to serve the claim in the underlying thing, who owns the blasted agricultural shares, why isn't it the same with the application to discover documents? I can't see why serving one application is somehow more or less of an intervention with the sovereignty of the state than the other.
Because in the first case, the English court is saying, we are going to be determining this dispute, this tort claim, and we are going to need to serve the defendant, and this is how we're going to do it. And that is widely accepted between states that courts will make that decision and then expected that they will follow the appropriate service process. It is not expected between states that the English court will take it upon itself to decide whether or not a person in Cyprus should give disclosure. That is a matter for the Cypriot courts. That is the difference between, even at this stage, even at the service out stage, the exercise of sovereignty through serving that person in respect of a prospective disclosure application. I think that's the only point I can make.
But the issue which seems to be common ground between you is that it has to be shown that England is clearly or distinctly the appropriate forum. Well, that raises the question, the appropriate to do what? For what purpose are you asking that question?
Well, the question whether England is the appropriate forum raises a whole host of conflict of laws principles, and it's for that purpose that one is asking that question. And I would submit that all the submissions I've made show that it's well established that it is the foreign court that is the appropriate forum for determining issues, determining whether or not people within its jurisdiction should be giving disclosure in aid of English proceedings. It's another way of putting the same point. It's the discretion, what is called the discretion, is clearly closely linked to the proper forum requirement.
Doesn't it all come back to jurisdiction? The question that has to be determined is whether under English and Welsh law there is power as a matter of our law to require a person abroad to produce documents in England. That is a question about the interpretation of English law to give it a shorthand title, and that must be an appropriate question for this court to determine. And since one of the people who might be interested in that is the people at the other end of the process, the Cypriot trustees, there's nothing of itself wrong in serving them with the application which would bring them here and allow them to contribute to the determination of the question. It may be right that the question on your submissions have to be answered in one way only, i.e. you can't do that, but the question as to whether or not it can be done and would involve a breach of sovereignty in the way that you describe is the second stage, as my lord says. It's not the first stage.
With respect, no, my lord, that the question of whether or not England is the proper forum to be considering whether or not my clients should give disclosure, whether it's a proper court, is prior and part of the decision whether to serve my clients out of the jurisdiction. You don't serve them first and then engage with that question. That is common ground, in fact. That is, I think it's in CPR Rule 37. That's one of the requirements before a party is served out of the jurisdiction. The court must be satisfied that England and Wales is the proper forum to consider that issue.
Suppose Section 34 said in terms that it applied to people holding documents out of the jurisdiction. And that is, in fact, the hypothesis on which discretion arises, because it is only if it impliedly means that we get to discretion. In those circumstances, again, wouldn't it be pretty clear that England was really the only place, England and Wales was really the only place where that could be done?
It's an interesting question, but I think we're not quite in that territory. I think that we're more akin to the territory in the Bankers' Book Act, where let's assume, I think that one would have to construe those words and think about what they meant and think about the extent of their effect and how much creed the court should pay to them. The fact that, in theory, let's assume that there is a technical jurisdiction, there is the possibility of an order being made under Section 34 outside the jurisdiction. So, contrary to my primary submissions, Section 34 has global territorial scope.
Well, it's only if you lose on that point that we get
course.
to discretion.
Yes,
So it's not a technical point, it's the hypothesis for discretion.
Indeed, but my point is that it's the jurisdiction is... We are there then basically in the position of Mackinnon, analogous to Mackinnon. We're in a position where there would be jurisdiction, but I would say that the court should be exercising a self-limiting limitation on that jurisdiction, just as in Mackinnon, so as not to offend the sovereignty of foreign states.
That's the next stage. That's whether you make the order, not whether you determine the question.
This is the same principle applies at the question of whether England is the proper forum, because it will almost always, if not always, be the proper forum for the foreign state to decide whether or not its subject, the people within its jurisdiction, should be giving jurisdiction to aid the English process.
But
That's why Cyprus is
Stanley
the
will
proper
stand
forum.
up and say, I want an order, please, to get documents which are currently located in Surrey. You will stand up and say, no, the person that this order is made against is in Cyprus. And then you have the self-denying ordinance on your analogy with Mackinnon. But there's a difference between the court can discuss the question whether to make an order and whether it should make an order. It must be able to discuss the question.
I completely accept that question arises at the second stage as well. But I am concerned with the discretion that arises at the first stage. And it's linked to where is the proper forum to consider this issue? Is it, in accordance with the practice of states that I've looked at, in accordance with the Hague Convention that exists between England and Cyprus, is Cyprus the proper forum to decide whether or not my client should give...
But not if we're applying the law of England and Wales, because the law of England and Wales is Section 34.
But that
The
gives jurisdiction...
convention isn't anything to do with the law of
There
England.
is always a separate question, once jurisdiction has been established, whether or not England is the proper forum. There's always that separate question.
The court has to consider it and decide it.
The court has to consider its jurisdiction and decide its jurisdiction, and then there is a question, nevertheless, even if it has jurisdiction, whether it's the proper forum to decide that question. And it has a residual discretion.
Can it serve out to get the person here to decide whether it's the proper forum?
No, my lord, that is a requirement that is part of the service out test. I started off by setting out the test for service out is do you fall within one of the gateways, and the third limb is England and Wales the proper forum?
So even if there's a jurisdiction, it can never be exercised.
We say it should never be exercised. Perhaps one could reserve exceptional circumstances where it would be impossible to engage, times of war or very extreme situations. I don't want to start enumerating them, but there might be exceptional circumstances. But as a matter of ordinary process, the proper process to allow the Cypriot court to decide these questions, and not for the English.
They should always refuse to serve out, because there's no point in serving out, because they would always refuse to make the order. That's it. I've got it now.
Thank
Sorry,
you.
being a bit slow.
We've had a lot of discussion about the personal nature of the obligation.
So just to pick up my Lord's analysis, that really goes to serious issue to be tried, because if there's no serious issue to be tried, because you should never make these orders against foreign defendants. That's a reason not to serve out, but that's not the way anybody's put it yet.
That is another way that the same conclusion could be reached. I think it's more direct to say England isn't the proper forum, but the same if my lord is right that that would be the consequence at the next stage, then it becomes no serious issue to be tried as a matter of two-step logic. Okay. I think given the time, I must move on to the third ground, which is about alternative service. I can take this very quickly. I think it's useful to turn up the case of M and N, which is
35.
35. Thank you, my lady. And the reason for that is that both we and the judge, Mr. Justice Jacobs, relied on that as a useful summary of the relevant principles. To summarise the position, what Mr. Justice Foxton described as the relevant principles of M and N is that where the Hague Service Convention is engaged, as here, where Cyprus and England are both parties to that convention, a very good reason is required to allow alternative service. Now, there's a prior question, before you even get into the service convention issue, which is that alternative service is only ever allowed where there's a good reason. That's CPR 6.15 sub 1. That's in paragraph 8 of Mr. Justice Foxton's judgment at the top of page 687 of the bundle. That's the general test for alternative service. So the first question is there a good reason? And delay is not a good reason. That's sub-paragraph 3. Merely avoiding delay or inconvenience will not be sufficient to constitute a good reason, even to get past that threshold. Then in sub 4, even if you've got through that, it will, where the other country, the country where the prospective respondent is a Hague Service Convention country, relief, alternative service will only be granted in exceptional circumstances or in special circumstances. And one situation where it has been held, this is now paragraph 9 sub 1, where such exceptional circumstances exist, is where an attempt is being made to join a new party to existing proceedings where the effect in delay in serving that person under the Service Convention will either substantially interfere with directions for the existing trial or require claims which there is a good reason to hear together to be heard separately. I mean, I've been in that position, in fact, where you realise at the last moment that it's necessary that another person outside the jurisdiction is a party to the substantive proceedings, is a defendant. They're actually the real person who's on the first defendant's case. It's prospective defendant who's got the assets or done something, and you need to get them in, and you need to get them in now in order that a trial take place where the same issues in the substantive trial are so closely connected that it's convenient to be heard together. And Mr. Justice Jacobs reasoned that the application against Foster's is such a trial, and we are to be brought in. We are to be considered we are being brought in as a new party joined as a new party to proceedings, so that the trial of both of the claims against us can be heard together. And our point is quite simple. That is a radical expansion of that principle, because this is not a trial. The application for disclosure against Foster's is not a trial. It's an application for disclosure. We are not being joined as a new party to proceedings. It's proposed that an order for disclosure be made against us as well. In fact, any delay in all of this process is a result of Mr. Gorbachev's own making, and this is an important point. And the judge paid no regard to this at all, but I've set out in my skeleton argument that, in fact, there was a long history of correspondence where it was suggested that Foster's were not the appropriate respondent, that Mr. Gorbachev should go through the letter of request process to go to Cyprus to seek these documents from my clients. At one point, Mr. Gorbachev's solicitors, late in 2021, in October, I think, said if Ms. Areti Cheridemu, the Cypriot lawyer for my clients, didn't voluntarily cooperate, then they would issue a letter of request. And none of that was done until the hearing before His Honour Judge Pelling, you see, where an application was made in the course of that hearing, at the judge's suggestion, seeking to join my clients as respondents to an additional application, or to an application against them as well. And so that delay is a result of Mr. Gorbachev not having gone through the letter of request process a year beforehand, or even 6 months beforehand, and having left it to the last minute. That's an important factor as well.
What did the judge say about that factor?
Nothing, I believe.
Well, that's probably your best point, isn't it,
Well, indeed.
on this ground?
I mean, that was the point that I put to the judge. The point made by the judge about us being joined as a new party to allow a trial to take place was not a point that I remember discussing.
It was His Honour Judge Pelling who made the order for alternative service, though, wasn't it?
Yes.
And then didn't this judge just not allow a setting aside of that order, or whatever?
Yes, but it's effectively a rehearing of the...
It's a rehearing, so again.
Well, he deals with it quite shortly, 110 on, doesn't he?
Indeed.
And presumably it's a point you'd made loud and clear, so he probably hadn't overlooked it, even if he didn't deal with it.
Absolutely. It's a point that's been made repeatedly.
What happens if you're right then? Do we have to decide it, or does it go back to Mr. Justice Jacobs and he writes out fuller reasons? Or, I mean, what happens next?
I would suggest that the conclusion will be there wasn't a good reason. That's a decision that it's appropriate for this court to make. There wasn't a good reason to allow alternative service, and that if you get to the conclusion that service out should be allowed, you should conclude that the service convention process should be followed, nevertheless, and to hold that no service has taken place. And so those are my submissions on grounds 1 to 3. Thank you very much.
And within time. Thank you very much indeed, Mr. Leary. Stanley.
May it please your lady. Let me start. I think it probably is worth making a start in the
Yes,
5
agreed.
minutes before the short adjournment. I think in my submission, it's quite clear that the critical issue is going to turn out to be the issue about the interpretation of Section 34 of the Senior Courts Act. And in particular, whether it contemplates or permits rules of court to allow an application of this sort under any circumstances. And in my submission, that is as far effectively as my learned friend has to go in order to say that there is no jurisdiction. Once one's through that, one is into areas of discretion. And that means effectively that on my learned friend's case, an application under CPR 3117 can never be made if the respondent to that application is not, at the time the application is made, physically present in the jurisdiction, which is effectively the retired doctor example that my Lord Justice Males gave. That is where it comes to. Now, on that question, there is no binding authority which will decide that question for you. And you may think that sometimes we are squeezing the pips rather dry of the authorities that we do have, which often concern different provisions, completely different questions. So one understands why one does it. I'm sorry, I'll probably do it too. But in the end, there is no binding authority on that question, and ultimately you're going to be having to apply your judgment on the meaning of the section. But what I think I can do is isolate I think, 3 different ways in which the trustees put their case, which sometimes merge into each other or overlap. I think they say, first of all, that the rules of court simply don't contain any provision which would ever allow service out of the jurisdiction of such an application. And they say that because they say that an application of this sort is not a claim and does not result in proceedings. And if they are right about that, then paradoxically, even if Section 34 said in terms, and this application may be made on a person outside the jurisdiction, we would still be stymied, because although the rules of court could have so provided, they have not, on my learned friend's case, so provided. Now, that whole question raises there's no extraterritoriality doesn't come into that. That is just a matter of the interpretation of the rules. And in particular of what is meant by proceedings in Gateway 20 and what is meant by claim in CPR 6.2. The second thing that they then say, I think, is, the second important point that then arises, and this is really the big point, is assuming that that's all wrong, and this is a claim, and it does result in proceedings, are they proceedings which are authorised to be brought by Section 34? That's the question. And they say no because of the extraterritoriality principle. And that's where I will be obviously focusing the bulk of my submissions. But I'm going to go to the bread and butter rules points first, because actually logically they come first. One only really sees where the Section 34 point arises when one sets it in the context of Gateway 20 and how Gateway 20 operates. So that's the structure I'm going to take. Now, can I be clear before I begin about two things, I think? It does not follow from anything that I'm going to be saying that Section 34 will be available in the ordinary run of cases, if I can put it that way, as a way of getting documents which are documents outside the jurisdiction. There are manifold areas of discretion which come in before any order to produce documents is going to be made. And as
are you going? Sorry to interrupt you. Are you going to be submitting that, as a matter of construction of Section 34, there is a distinction between documents within the jurisdiction and documents outside the jurisdiction?
No, my lord, I don't. In other words, I hadn't thought about it, but I'm going to be submitting that it operates in a way that once Section 34 simply provides for an application to be made for documents, the jurisdiction to make rules of court extends to making rules of court which allow an application to be made against a person outside the jurisdiction. At that point, when it comes to whether the order should be made, in my submission, it is not a matter of jurisdiction, but a matter of discretion, which is effectively turning the point on its head, the same conclusion that Mr. Justice Hoffman reached in McKinnon, where he said, well, we would not normally do that, but there are exceptional cases in which we might. So I would put it as a matter of discretion. Your Lordship, I looked at Section 7 of the Bankers' Books and Evidence Act, which you'll be surprised to hear was not in my mind. The argument might have been available in McKinnon because it talks about inspecting books and records, which you might have said had a kind of territorial cover, but it doesn't seem to have been the approach. That doesn't seem to have been the way the case was argued by Mr. Hurst as he then was. And it certainly does go further because in McKinnon, a criminal case called Grossman is discussed, and that was certainly a case where there was unquestionably jurisdiction because the person concerned was a British bank, so there wasn't even the branch question which there was in McKinnon. In other words, in that case, it was somebody who clearly could have been required to come into the jurisdiction to allow the inspection to take place. So that's the way I'm going to be putting it. And so it doesn't follow, therefore, that in cases like Nick's, for instance, that you would expect the order to be made or even permission to serve out to be given. And I will come back to that because I think, surprisingly it may be, I agree with my learned friend that the discretion does apply at the jurisdictional stage.
But if you know you're not going to make an order, then there's no point in allowing service out. But if it's uncertain, for example, as to whether there are exceptional circumstances, then you may have to allow service out to see whether or not those apply.
If it's clearly inappropriate, in other words, if you certainly would not make an order because it would if, among other things, it would clearly be an unjust, undue interference, then you would not permit service out. That's exactly the point. Now, my Lord Justice Males is right that maybe we've been looking at that wrongly in terms of forum non-conveniens. I wasn't actually necessarily thinking of it that way. If one looks back to VTB, forum non-conveniens has a sort of second grace note behind it. It's clearly the most appropriate forum, and it is appropriate that the case should be brought in England. Now, one way of looking at it would be that it falls under the second thing. The other would be that it falls under the basic principle that one would not order service out of a claim which one was then going to refuse. So on either of those bases, discretion can be considered at that stage. My lady, I think it's 1 o'clock. I think that is probably a convenient time for me to stop for the short adjournment.
Thank you very much indeed. We'll start again at 2 o'clock. Thank you.